Good morning. We will give just a moment to clear the waiting room. Good morning. This is the voting hearing of the licensing board for the city of Boston. Today is Thursday, January 16th, 2025. This hearing is being recorded and will be posted to the city of Boston's website. While the public is encouraged to attend, there will be no additional testimony accepted this morning. Begin with the license premise inspection hearing, which occurred on Tuesday, January 14th, 2025. Item number one, Ulivo LLC, doing business as Cunard Tavern, located at 24 Orleans Street in East Boston. Date of the incident, August 30th, 2024, overly intoxicated employee, manager, possible drugging in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 138, Section 69.
I think this was a series of really bad decisions, but they're written up for possible drugging, which I didn't see a violation for.
Sorry, I didn't know you were done. I agree. Once again, I think that what happened was serious. Is there any way we can be reflected on the docket?
Yes.
I think even correspondence, docket and correspondence.
What would you like on the docket?
I mean, this was an employee who was drinking on the job, correct?
Two.
So, yeah. So that is definitely not.
How about overly intoxicated employees on the docket?
Yeah. I mean, it could just say board notes an incident that didn't rise to the level of violation.
Yep.
Something like that.
Yep. Yeah, board notes a serious incident that did not rise to the level of violation. Great. And in that correspondence, Commissioner Saxon, what would you like conveyed?
Well, I definitely don't think that employees should be drinking on the job. So adherence to rules and regulations regarding that.
Great.
And I guess I might add that when I got into my questioning, I was really concerned about the level of staffing there. And they actually talked about how the manager essentially cut off the bartender, like, the person questioned their behavior and they said, I'm your manager. This is something I've said in the past, is that all employees need to be empowered to confront situations like that. So training regarding, even though it's a manager to a subordinate, that the subordinate needs to be empowered to say, like, no, that's not okay, that kind of thing.
So correspondence, adherence to the rules and regulations, training for all employees regarding their requirement of following the rules and regulations and making sure that others do as well.
Danny, this is the one where he said that the video wasn't working because it was too hot out.
Yeah, the recording of the camera equipment had overheated.
Yeah, I think that should be addressed too and put on the docket.
Yeah, we don't want to forget that either.
Right, especially since they had a year to fix it.
Great. So we'll also note on the docket that the video equipment was not working, and that will be reflected in the correspondence as well. Okay. Item number two, licensee did not appear, will be rescheduled to the next available hearing date. Item number three, ZAA KFL LLC, doing business as Biliaris Columbia, located at 28 Bennington Street in East Boston. Date of the incident, July 8th, 2024, assault and battery, patron on patron, in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
Based upon the testimony, the manager did separate the two parties once the assault had happened. This was in July before they upgraded their video camera, which they have submitted to us, proof of that being done since then. So I don't see an issue. I think video would have been helpful, but they have since updated it. So I can't hold them to that. In my professional opinion, they should have called the police, but they weren't written up for that. So I don't see a violation for the assault and battery. I don't think it was foreseeable given the circumstances as they were described.
Yeah, I had my doubts about the circumstances, but without the alleged victim testifying live, I couldn't get there. So, you know, I have doubts about the video situation. I would like that once again reflected on the docket that they had an excuse for not providing video. And you know, in the future, if they don't have video in a situation where they should have video, a negative inference may be applied.
Right, technical no violation, but I do think that it should be noted that they should have called the police, whether it's correspondence or on the docket or both.
A violation, it will be reflected in the docket that licensee should have called the police and also that the video equipment was not working at the time of the incident. Item number 4, Goosebin LLC, doing business as Medallo, located at 411 Chelsea Street in East Boston. Date of the incident, September 1st, 2024. Assault and battery, patron on employee, in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
I'm sorry, I'm just looking at my notes here. We did receive a lot of video on this one. Jump in wherever you want. The staff didn't call the police or request medical attention. I think the testimony was they didn't believe that medical attention was required, but I do think the situation as it was described in the actual video of the assault, they should have called the police. The bouncer did break up the fight, but I don't think technically I can get to a violation. I do think there was the management, specifically the staff, specifically the bouncer, should have done more than just break up the parties. I think this was something that should have been a call to the police.
Yeah, it's hard the same way, a potential failure to call the police, but they weren't written up for that. The story that was in the police report didn't match up with the story told, and it seemed like the employee might have been going back to that group to settle a score or something like that. So I wasn't able to have patron on employee, so I had no violation, but just on technicality.
Yeah, I agree. I think failure to call the police should be docketed.
A violation, the board will note that the licensee should have called the police in this incident. Item number 5, Tremont 958 Restaurant Corporation, doing business as Slade's Bar and Grill, located at 958 Tremont Street in Mission Hill. Date of the incident, September 22nd, 2024. Failure to disperse large crowd at bar let out and excessive noise in violation of Mass General Laws, Chapter 138, Section 64, and expired licenses in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.02b.
Just focusing on the failure to disperse, I give management credit for having reviewed what happened on this day and making changes since then. They now close earlier. They have more people outside at closing time. The testimony was it was like an unusually warm evening, and so people wanted to continue the party on the street. These things should be taken into consideration. It should be foreseeable that on such a warm night that your crowd isn't going to necessarily disperse on their own and that more needs to be done. It sounds like there was over 100 people in the street. To me, that's a real public safety issue. I do see a violation, and my vote would be just for a warning.
I didn't get to the point of a violation yet. I know that they've had other issues on dispersal. But for me, on this date, I'm not sure if we had the conversation with them about, you know, they should be on notice. They testified they had 4 people out there making their best efforts to disperse people. Not being there, not seeing, you know, what those efforts were. I take them at their word that they were trying. I would be more comfortable with something in the area of like docketing that now they're on notice. Even though they've told us now we're accepting, they're on notice that they have issues at dispersal and that they have to kind of stick to the plan that they told us they have. That's where I would be on this one.
I agree with docketing.
No violation docketing. Is there a dispersal plan the board would like to see, or are we comfortable with taking their word?
I mean, we just get it in writing from them,
Yeah,
what they said.
yeah, about how they're gonna have the 4 people outside, they're turning off the music earlier. They're having a phased exit as opposed to everyone leaving at the same time.
Great. So the board would like that in writing from the licensee.
Yep,
And Churro and Joyce, are you still voting for a violation?
I will defer to my 2 colleagues and I will go with docketing it and issuing correspondence.
Great. And requesting a written dispersal plan.
Yes.
Item number 6, Courtyard Management LLC, doing business as Courtyard Boston Downtown, located at 275 Tremont Street. Date of the incident was October 14th, 2024 and November 11th, 2024. Refusal to cooperate with Boston Police in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.10A and B. Refusal to identify oneself to Boston Police in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.10A and B.
Commissioner Curran requested additional information. Is what we received yesterday sufficient?
What we received yesterday is an email stating that the employee in question was hired at a time when his manager was on paternity leave, and therefore he was never scheduled to attend training.
Okay, and Commissioner Curran wanted to know documentation that the training happened after this? Or was it that this particular employee received the training?
Receive the training, so
Okay.
it's a no. So
Okay.
it answers the question. This particular employee did not receive training from them.
And-
Right?
Yeah, and then given that fact, I believe that this would have been foreseeable. And so I see a violation.
I see one as well.
I agree.
Based upon, they don't have any history of this with us, so a first warning.
Yes.
Violation with a first warning. Item number 7, Bar Taco Fenway LLC, doing business as Bar Taco, located at 1321 Boylston Street. Date of the incident, November 21st, 2024. Persons under 21 in possession of alcohol on premise in violation of Mass General Laws, Chapter 138, Section 34A, 34C, and 6464A.
Question for Danny or the commissioners. In my notes, I asked a question, were they Massachusetts licenses? Do we know if they were? We don't know.
They said they were from all over.
Okay, so and the testimony was that they were young patrons, they looked young. And there was 10 of them. So I see a violation here.
I saw one as well.
I did too.
As far as the penalty, do they have a history, Danny? I don't have it in front of me.
Yep, I'm pulling it up right now. This is a new licensee.
Oh, no.
There's no history.
So given that there was 10 people, balancing that with the fact that this is a new licensee, I do think 10 is egregious in one instance. My vote would be for a 1-day suspension held in abeyance for a year. If they don't have any other similar violations, it would be removed from their from the docket. Not removed, but it would not have to be served.
I agree. I'm also concerned with their kind of practice regarding like mixed groups. It sounded like that if, you know, especially a peer group, they're not really paying attention. Their plan is to serve 21-year-olds at the same, like say a group of 10 and not serve other people. I don't know if we need to put them on notice that, you know, that's kind of they're playing with fire there, I guess, you know? It's not like a parent with a child with a mixed group. It's a peer group, mixed group, you know? And they just don't really seem to be on top of that.
And we've seen this before at other new restaurants, where they do the exact same thing. It's more like ignorance, but we could send correspondence. I mean, this is a business decision on their part, but we could flag it for them that they might want to reevaluate their business practices.
Yeah, there's a really high risk of pass off, so. Yeah. I do agree with the 1 day suspension in abeyance for 1 year.
Violation, 1 day suspension to be held in abeyance for 1 year, and a correspondence regarding the importance of ID checking for all groups, especially mixed groups of patrons.
They also, I'm sorry, getting back to that one, they stated on the record that they have since changed their procedures and now a manager oversees it. I'd like to see that in writing so that we have that with us next time, given that it's a new licensee.
So request in writing, what is their procedures for identifying patrons?
Mhm.
Right. Item number 8, PAG Tremont LLC, located at 645 to 647 Tremont Street. Date of the incident, December 7th, 2024. Blocked fire exit by a blacked out curtain in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.06A.
I see a violation.
Yes,
I don't think they have history, correct?
This is a new licensee as well.
The licensee, so written warning, first warning.
yes.
Violation, the first warning. Moving on to the transactional hearing, which was held yesterday, Wednesday, January 15th, 2025. Item number 1, Mothership Alewife LLC, doing business as Revival Cafe and Kitchen, located at 15 Necco Street, has applied for a common victualler license. Manager Liza Shirazi, hours of operation 7 a.m. to 4 p.m.
I'm sorry. My vote is to approve.
I agree.
I agree.
Item number 2, Day and Night Exotic Cereal Bar Boston LLC, doing business as Day and Night Exotic Cereal Bar Boston LLC, located at 6 Tremont Street in Brighton, has petitioned to change the corporate name to Sweet and Comfy Brighton LLC, has petitioned to change the DBA to Sweet and Comfy, and has petitioned to change the operating hours to 6 a.m. to 3 a.m. They stated on the record they would amend that to 2 a.m.
Okay. I vote to approve the change in the corporate name and the DBA. As far as the change in the operating hours, I vote to approve 2 a.m. We've recently approved other businesses in the same general area at 2 a.m. However, I do want a written plan about Uber Eats and DoorDash, as transportation has flagged issues they've seen in other neighborhoods, but I could foresee this becoming an issue if management doesn't think it through. So I'd like to have that as part of their file.
I agree across the board.
I agree.
Great, granted with a 2 a.m. closing time, and the board will request a written plan regarding pickup and takeout by third-party delivery drivers. Item number 3, Master Inn Corporation, doing business as Burger King, located at 944 Bennington Street in East Boston, has petitioned to change the operating hours to 24 hours a day.
I vote to approve the change as requested.
I do as well.
I agree.
And item number 4, Tuscan Kitchen of Boston LLC, doing business as Tuscan Kitchen, located at 53 Northern Ave, has petitioned to change the manager to Damaris Surset.
I vote to approve the change in manager.
I agree.
Item number 5, Bennington 1004 LLC, doing business as Renegades Pub, located at 1004 Bennington Street in East Boston, has petitioned for a change of ownership interest.
I vote to approve the change.
I agree.
I agree.
The remaining items 6 through 10, are new license applications. Chairman Joyce, would you like to vote on these today or defer until after we've heard all the December 6th applications?
I would like to defer until after we hear all the December 6 applications.
Items 6 through 10 will be deferred. Non-hearing transactions, the following are applying for a new common victualler license at a previously licensed location. Item 1, Zarhan LLC, doing business as Emmy Bakery and Cafe, located at 100 City Square. Manager Cesar Yavuz, hours of operation 6 a.m. to 11 p.m.
I vote to approve.
I agree.
I agree.
Item number 2, Non-Fun To Go LLC, doing business as Evan To Go, located at 411 Adam Street in Dorchester. Manager, Non-Fun, hours of operation 8 a.m. to 8 p.m.
I vote to approve.
I agree.
Item number 3, HJZ Boston LLC, doing business as Hey Tea, located at 160 to 162 Harvard Ave in Alston. Manager, Jason Blackburn, hours of operation 11 a.m. to 10 p.m.
I vote to approve.
I agree.
Following have applied to make changes to their existing common victular license. Item number 1, V Healthy LLC, doing business as V Healthy, located at 4166 Washington Street in Roslindale, has petitioned to change the operating hours of the business to 8 a.m. to 5 p.m. Monday through Friday and 9 a.m. to 3 p.m. on Saturday.
I vote to approve.
I do as well.
Item number 2, Virtual Fulfillment Center LLC, doing business as Virtual Food Court VFC, located at 313 Old Colony Ave in South Boston, has petitioned to change the DBA to VFC Eats, has petitioned to change the ownership interest to Ahmad Qasim, Mohammed Ali, and Omar Nimatala as 25% each. This is the removal of one member, and has petitioned to change the manager to Ahmed Qasim.
I vote to approve the changes as requested.
I agree.
Following have applied for a one-day amendment to their existing license. Item number 1, RIA Brewing Inc., doing business as Democracy Brewing, located at 29 to 35 Temple Place, has applied to extend their closing hour for 1 hour to 2 a.m. for a DJ night on January 18th, 2025.
Vote to approve.
I agree.
Thank you, Commissioner Saxon. And item number 2, AHF Speedway Holdings LLC, doing business as Charles River Speedway, located at 1420 to 1440 Soldiers Field Road in Brighton, has applied to extend into the contiguous annex for an art exhibit opening party on January 30th from 6 p.m. to 11 p.m.
Vote to approve.
I agree.
I agree.
The board has before them a list of applications for special one-day alcoholic beverages licenses, which have been administratively reviewed by staff and approved by the board. And on old and new business, item number 1, for a vote, the board has received correspondence from Bennington 1004 LLC, doing business as Renegades Pub, located at 1004 Bennington Street in East Boston, requesting administrative approval to increase the capacity from 34 to 43 based on new certificates from ISD.
Vote to approve.
I do as well.
And item number 2, the board had noticed a discussion regarding the granting of new alcoholic beverages licenses pursuant to Chapter 202 of the Acts of 2024. Chairwoman Joyce?
Well, I had hoped we would be able to have this discussion today. We realized that we have one more application that made the December 6th deadline that we're hearing next Wednesday. So I'd like to defer this discussion until the 23rd.
Sounds good.
So item number 2 will be postponed until the January 23rd voting hearing. Thank you. Those are all the items before the board this morning. That will adjourn this hearing. Thank you all and have a great rest of your day.
Thank you. You too.
Thank you.